Hello, everybody. Good afternoon, and thank you for joining us on the hottest day of the year. My name is Charlie Banner, and welcome to the 5th episode of Have We Got Planning News for You, our hopefully informative but also informal and light-hearted take on recent events in the planning world. At Sasha's insistence, we are a Spurs-free zone today, or at least for now. As usual, you can all provide questions or comments on the Q&A function, not just about the relative merits of Arsenal and Spurs. Remember, it's the Q&A, not the chat function. I think at the bottom of your screen, if your format of Zoom is fine. And we'll follow up any points after the show on our LinkedIn page, which can we once again urge you to join. As you'll know by now, this is a free show, but can we reiterate our usual encouragement to you to make a donation if you feel so obliged to the NHS COVID-19's Just Giving page or to a local charity of your choice. Without further ado, let me introduce the panel. So can I ask each of you in turn to say who you are, where you are, and what you're drinking this evening? I'll say I'm on the Cobra this evening in anticipation of a curry tonight. So over to you, Mary.
Good evening. I'm Mary Cook, aka Hermione Granger, and I'm Town Legal from Wandsworth.
Hi, I'm Chris Young from number 5 Chambers, and I am obviously in Hogwarts Castle, as is always the case. I don't know if you can see, Charlie, over my right shoulder, my owl there. That's not a euphemism. That is genuinely an owl, and I've called him Presumption. And as you'll see at the moment, that bird isn't flying. Okay, and what I'm drinking today is Doom Bar, which is how I'm feeling if suggestions that all inquiries will be virtual forever actually comes to fruition. But let's hope pins row back from that.
And hello, Charlie, or rather, I should say, Panan Dar, requested on behalf of one of my relatives to wear a Welsh rugby shirt in honour of my great granduncle, who was the first man to kick off for Wales against England at Twickenham, despite the fact I have not a drop of Welsh blood in my body. But there we are. I've now done my duty. And I'm speaking to you from the heart of Lancashire, which remarkably is sunny. First time in 20 years.
And my name is Sasha White. I'm in Oxfordshire, and I don't want to get Paul chippy, but I'm wearing a World Cup winner's shirt, which is painting. And I'm also joined by my dog, because we reached the view that he would definitely have a good sleep listening to planning for an hour. So he's having a lovely snooze behind me.
First time you've been on the winning side for a while, isn't it, Sasha?
No, I know that's not true.
But that doesn't count. And of course, we have a very special guest today, our second commander of the British Empire on this show, no less than Steve Quartermaine. Steve, hello, welcome. Thank you so much for joining us. And perhaps you tell us where are you joining us from and what are you drinking this evening?
I'm joining you from East London. I'm delighted to be on the show. It's a great show, folks. Do keep this up. It's fantastic. And I'm drinking, well, to be honest with you, I'm just drinking red wine.
Well, we'll be doing an interview with Steve in the second half of the show, but Steve, as I've said to our other guests in the past, please do chip in at any stage in relation to any of the other things we're talking about, to the extent you'd like to. That would be fantastic. Now, before we get started on the serious stuff, I should let you know this. After I put on screen last week that garden centre pub internet meme image, a couple of you suggested to me that we have a meme image of the week at the beginning of every episode. Well, I think that's a really great idea. However, we are a family show, and unfortunately, all of the meme images I've been sent this week, largely by certain viewers of this show, have two things in common. One of which is they're not suitable for family viewing, and if you know the other, you're a very bad person. So, in the absence of an internet meme, here are some photos of what some of us have been getting up to this week. So, Sasha, you've disabled share screen.
Oh, sugar. Okay.
Deliberately.
After Sasha, I absolutely promise. Here we are. Oh, goodness me.
This is unwarranted advertising. Hold on a second. That wasn't necessary.
Our viewing figures have now tripled as everyone's making to think what the lights on Sasha's computer.
Yeah.
score go, and if not, I shall. Well, I'll tell you what, Sasha, we'll kick off, and I shall show people the delights of these photos. There's one photo in particular that I know Paul and I are especially keen to
If you're going to start, Banner, I'll retaliate.
No. Anyway, so I urge Sasha to let me share the screen, because everybody must be dying by now, if they've seen what I'm named, to learn what Chris's nickname in his own household is. And there's a particular I wish to reveal this fact. So Sasha, you get working on that. In the meantime, let's kick off with our first topic of the week, and it's court case of the week, as usual. And in fact, Sasha, before you work out how I can publicly humiliate Chris once more, can you tell us what's been keeping the planning court busy?
Yeah, absolutely. And I want to talk about a case, particularly for Paul. I know how much he loves talking about the great public schools of Britain. I'm going to talk about Harrow School. And the case I'm going to discuss is Harrow School and the Mayor of London, exactly, and David Holgate's decision of last week. Now, this is a case that I thought a bit about what to talk about this case, but it obviously affects the consideration of Metropolitan Open Land, which I know Chris is a maestro over after his decision in Bromley last year. But rather than talk the substance of the case, what I wanted to bring to our viewers' attention, I think there are 4 important facts about it. The first is all of us know various characters at the bar, and John Steele, not unsurprisingly, is the man who loves Harrow School. You can hear him talk about the mayor's volte face all the time, and it's writ large through the decision. But what I wanted to bring to our viewers' attention, and all of us find preparing for inquiry is slightly difficult, but the one thing that's really clear in this decision, basically the mayor challenged the decision of the Secretary of State to grant consent on that scheme, which is effectively a replacement sports facility on MOL and a replacement science building. Went to inquiry, the inspector recommended approval, the Secretary of State agreed with the inspector's recommendation, but unlike the inspector, found that endorsing Historic England's position that there was harm to heritage assets. Now, this was challenged by the Mayor in the High Court, and the points I wanted to talk about is, first of all of us who spend hours, and for all you consultants and officers who get fed up with Chris or Paul or Charlie taking 7 hours in con, it is noteworthy that one of the things the judge says in this case is that the point at dispute was effectively the effect on the purposes of the MOL in that case, and particularly in relation to the harm to historic towns. And one of the things that the judge, and we know Mr. Justice Holgate is going to say it as it is, criticises as the evidence that was put before that inquiry, and the word he used was lamentable on this point, which was subsequently subject to ground 1 and 2 of the challenge. The second point, which is also a very important lesson for us all, is when you promote alternatives, and in this case the Mayor, one of the views argued by the Mayor at the inquiry was that alternative sites existed for the proposed development that would not utilise an MOL site. And another point that Mr. Justice Holgate refers to was the inspector's conclusion. The inspector was pretty firm about this and called the alternative concept that the Mayor relied on do not stack up even to the most rudimentary assessment. So again, it's a lesson when considering alternative schemes that they really got to be credible to stand scrutiny. But the point I wanted to bring, the third point, was about law and statement of common grounds. And I know from doing Gates some years ago, there's always the question about to what extent can an inspector change the agreed position between the parties. And in that case, the Harrow School had agreed in the statement of common ground that effectively there would be harm to the purposes. During the inquiry, their heritage witness did not accept that in evidence and took the view that there wouldn't be harm to the purposes, and particularly heritage harm. And that was the evidential position of the school. And one of the things that the inspector did was endorse that position. And one of the grounds was to what extent can an inspector disagree with a statement of common ground. And again, the judge took the view there that effectively it was reasonable to do that. And the inspector, it was clear when a witness clearly makes a comment which is contrary to the agreed position in the statement of common ground, all the parties are given notice that that process is actually happening. And the view is taken, pretty much reading through the decision, that the mayor should have been alive to the change, basically. It was quite clear. And additionally, again, what the judge was pretty unimpressed was the skeletal material that was produced in the evidence that relied on this particular ground. So finally, the fourth point I wanted to make is about costs. And for all of us who eternally discuss the relationship between the costs, application and decision and the substance of the case, that this decision is a case in point that the cost decision is completely separate to the substantive decision on the planning appeal. And in that decision, although the judge rejected the 288, he found in favour of the judicial review seeking the quashing of the costs. And it's also, just to say for all inspectors who are listening, that it's very clear that when you give a costs award, your use of language is critical and mustn't use phrases which imply limitations, as was done in that case, on the extent of the award of costs. So it does require inspectors to think very carefully, and indeed there's 5 of us, and maybe Steve in his new life, to consider the basis of applications. So those are the main points I take away from that decision.
Thanks, Sasha. You mentioned the judge being Mr. Justice Holgate, David Holgate. I was just, as you were saying that, looking through the attendee list with a degree of trepidation, because I do know, as it happens, that this Justice Holgate is a fan of this show. I don't think he's amongst the attendees unless there is somebody cryptically who's given their name as Dave. I'm relatively sure that isn't Mr. Justice Holgate, but if it is, hello, and if it's not, happy Dave, whoever you are. I'm told apparently I'm not allowed to read out the names of people who are attendees. Our marketing people say that's a heinous breach of the GDPR, and I get hauled out of chambers by the GDPR police. But hopefully Dave is sufficiently generic to avoid that crime. Chris, what do you make of the decision?
Well, no, I don't want to delay matters. Sasha's covered it fairly well in his detail. I think it's interesting. It's another proposal in the MOL, and I could talk about that for a very long time. But what's interesting is that you apply the same test, the very special circumstance test, to MOL, and we see the school being successful there. And that should be very encouraging, because that's just the test that is applied in the Greenbelt. Obviously, we're talking about something different here from a lot of the housing schemes we do. But again, you know, it's not to be seen as sacrosanct, Greenbelt or MOL.
And I think we're just in time now. I would like Paul to get his checkbook out and make the appropriate donation to Harrow School to help them build it.
As an alumni of Raincliffe Comprehensive School in Scarborough, there's just no way I can do it. It's enough that I'm having to wear a Welsh shirt to satisfy my relatives. But that's a step too far. I'll wear one. I'll write the check in the event that you wear your Tottenham shirt, Sasha.
Yes. Okay. Deal. We have that on record. Now we've got three decisions to deal with today, because there's been so much happening last week. 2 planning appeal decisions and one of the many local plan exchanges. So the first of the Secretary of State appeal decisions is one from Waverley, every barrister's favourite district. Mary, you'll tell us about that.
The gift that keeps on giving. So this is an appeal decision about a scheme for 65 units outside the built-up area boundary, and the developer put forward a 40% affordable housing offer, which was an increase above policy, a 10% increase. The application was made as long ago as December 2017. There was a hearing in June of last year. And now cover your ears, fellow panelists, because this could upset you. There were no barristers employed on this appeal. The Secretary of State recovered the appeal on the 15th of August, which curiously was the same date as the inspector's main report to the Secretary of State, recommending that permission be granted, applying the tilted balance under paragraph 11, because there was no 5-year housing land supply. Farnham neighbourhood plan had been made in July 2017 in advance of part 1 of Waverley's local plan. And that neighbourhood plan had allocated a minimum number of houses of some 2,201. And it contained actually a lot of policies that look more like a local plan than a neighbourhood plan, but I digress. The local plan, in the end, allocated more houses to Farnham than did the neighbourhood plan, and that's because Waverley were told to meet Woking's unmet needs, you may recall. At the time of the hearing, the review of the Farnham neighbourhood plan was in the very early stages, and they were looking at that stage to increase their allocation by 450 houses to take into account this unmet Woking need. And the appellant argued that the neighbourhood plan was out of date, but there were conflicting decisions about whether the failure of the neighbourhood plan to allocate enough sites rendered it out of date, or whether it simply meant that you would give it less weight because of the breach of the strategic policies. The inspector said that that matter was neutral, and he didn't apply paragraph 11D because of it, but he applied 11D because of the 4-year housing land supply. He said that because the neighbourhood plan did not contain the policies and allocations to meet the identified requirement, paragraph 14 did not apply. And so that was the basis upon which he recommended that the benefits carried significant weight, that the adverse impacts carried only moderate weight, and therefore the Secretary of State should grant permission. And what did the Secretary of State do? Well, he waited until May 2020 before he issued his decision. And in that time, Waverley's 5-year housing land position changed. And by the time of the February housing delivery test, Waverley had moved from being a 20% buffer to a 5% buffer local authority. But there was still no 5-year housing land supply. But the revised neighbourhood plan made progress and indeed became a made neighbourhood plan, literally, as it were, as lockdown began. And so the Secretary of State found that although there was only a 4.5-year housing land supply and paragraph 11D was triggered, so was paragraph 14, because the revised Farnham neighbourhood plan was now promoting and allocating sites of insufficient number. And so he found that the proposal, that the paragraph 14 applied, that the neighbourhood plan had been revised within the last 2 years, that it contained the right policies and allocations to meet the identified requirement, that they couldn't show a 3-year they could show a 3-year housing land supply, and that the housing delivery test was 45%, above 45%. And so he refused planning permission. And so the moral of that story is that rather like the Secretaries of State did right at the beginning of neighbourhood plans, they are still prepared to delay decisions in order to let neighbourhood plans catch up and thus thwart development.
Thanks, Mary. I mean, I completely agree with the timeline. I was looking at this decision earlier today, and the application was put in December 2017. It was refused in March 2018. They had their hearing at the time, wasn't recovered in June 2019. You can't really blame the developers who them or their financiers would have invested considerable money in that scheme, even without the barristers. And you can't really blame them for thinking that they would have got in before the neighbourhood plan, the revised neighbourhood plan, got to the stage where it was to carry significant weight. And then, of course, as you say, it was recovered post-hearing in August 2019. The neighbourhood plan examination was in October. The referendum was in March. Made in April, decision refusing permission on the base neighbourhood plan in May, and talk about being overtaken by events, eh? And even by the time of the hearing, the appellant could reasonably have expected a decision by the time the neighbourhood plan went to the examination. And I mean, it's not unprecedented. Sorry, Sasha, go on. Go after you.
I just wanted to say, I think Steve, I want to make 2 comments. Steve now feels he's on a Lions tour to New Zealand. Firstly. Yeah. Secondly, I do think I know he's obviously taken various positions. Can I add a 4th one, poker player, because he's doing a cracking job of giving no nothing away as we discuss these various Secretary of State decisions. Sorry, Charlie, my intervention.
And they say they give nothing. I would pretty much wager my house that if there were a judicial review, statutory review challenge of this, and if disclosure was sought, you would find there were no contemporaneous notes if anything was discussed about this case. If you've read.
I will say something.
Steve.
Obviously, clearly, so far the cases have been relating to Secretary of State cases, so it's no surprise that I'm not going to comment on them.
Of course.
Poker, of course, has never been my fault. I've never had enough money to afford to lose. But what I would say, though, is just in passing, and I don't say this by way of justification or excuse, but just throw your mind back as to what was happening between the back end of November and March. I seem to remember there was a general election, and there, which of course is a period of purdah. We don't issue decisions which are other than the basic stuff, and also we had a reshuffle of ministers. Now, every time you get a change like that, not only the election, but a change of ministers, there is time that is taken to, within the system that does lead to delay. For example, you wouldn't expect a minister to take a decision unless they've had some insight into what the government's position is on propriety and the way in which casework works. That has to be taken before a minister takes a decision. So I just want to try and dispel the conspiracy theory, which is underlying some of the comments here. This is sometimes just how it happens.
Thanks, Steve. That's a really, really interesting insight. Thank you for that. A couple of quick points as well. Firstly, the Secretary of State also refers, I think, was at pains to refer to Christina Downes' decision in the 9 Mile Ride case, which we discussed a few weeks ago, where she reduced the 5-year supply. Sorry, Chris, to remind you of that. Couldn't help it. She was
not my show, is it?
Wait, Charlie, what was the name of that case again?
Sorry,
I use my nickname in the appearances.
Later. Anyway, she reduced the 5-year supply due to the effect of COVID-related delay. The Secretary of State specifically flagged up that decision and that issue, then specifically ducked it, saying he didn't need to deal with it. But I think it's a further indication of COVID-related delay likely being an issue in the future. And secondly, those who are not affected by neighbourhood plans in Waverley would at least be re-enheartened by the fact that the Secretary of State did uphold the inspector's finding that there wasn't a 5-year supply in that district, which is a matter that's been the subject of some discussion. Now we need to move on to our second planning appeal decision, and from the south to the north, in the interests of balance, etc. And who better to tell us about what's been going on in the north than the King of the North himself?
Yeah, well, thank you, Charlie. And as a very proud Yorkshireman, it's an absolute delight to be discussing anything to do with Yorkshire. It's a particular delight to be doing it with a former chief planner who started off his life in Yorkshire. And it's a joy to see that he's now joined the cast of Gogglebox. So enjoy that, mate. That just demonstrates I'm a second-rate plagiarist because I nicked that from a comment that was made on the chat. Yeah, so this is a case which deals with that perennial in my neck of the woods, which is the York Greenbelt. At paragraph 8 of the Secretary of State's decision, the Secretary of State engages in what can only be described as humour. It's not a great joke, but it does point out that the last time that a DPD was adopted in York was 1956, when Her Majesty was barely just on the throne. In fact, York Greenbelt is one of those joys for me, given I've been banging on about the need for some sort of strategic guidance that transcends local authorities, because it's one of the areas where regional guidance still exists. Regional guidance exists in York because it tells you that there will be a Greenbelt around York and shows the broad extent. That survived the abolition of RSS. Tragically, it doesn't tell us where the outer boundary is. It doesn't tell us where the inner boundary is, which allows for a huge amount of debate on the issue. This is a site which was agreed by all parties that it should be treated as Greenbelt, even though we don't know where the boundaries of Greenbelt are. You couldn't make it up, could you? It was a proposal for 516 houses. All parties conceded that it was that there was a high housing crisis in York. The developer proposed an additional 5% over and above policy for affordable housing. And interestingly, in the context of of that proposal, the Secretary of State gave additional weighting to that. Disproportionate value, as it's been reported, was given to that addition in the context of a housing crisis. But nonetheless, because of the possible effect on an adjacent bog, which glories in the name of Askham Bog, in my neck of the woods, you can spot where the Vikings have been because of the joy of the names. Anything with an X in, or an Og or an Ug, is where the Vikings were. Well, this is one of those locations. Well, Askham Bog is a triple SI, and the Inspector Clark concluded that you could not exclude the possibility of an impact on Askham Bog. He doesn't refer to the prospect of the precautionary principle, but that's in effect what he did. I think this case is interesting because the local housing crisis was given weight. The additions to affordable housing was given weight. It's all discussed in the very special circumstances. And maybe I'm reading too much into this, but had it not been for the inability to exclude harm to Askham Bog itself, I think this is a site which would have also been granted consent in the Greenbelt. It's an interesting case and hopefully a sign of things to come. And I do note that despite the ongoing examination of the local plan in York, its content was given limited weight by everybody. Anyway, good luck. One day I'll retire, but sometime after I do, York will adopt a Greenbelt.
Harry, what do you think? Is it distinguishable from the Greenbelt consents, as Paul said, the recent ones from, like, Chris? To be fair to Chris's victory, he does occasionally win some cases.
Yes, in short, yes. I mean, it was a greenfield site, and the bog proved to be the undoing. And I think that shows that the danger of dealing with an unknown when your task is to prove no harm. And effectively what happened here was the inspector said that the hydrology was complex and there was no absolute certainty as to the bog's source of water supply. So on that basis, they went down. Another point, though, of interest is that one of the other things that was argued was that the bog was isolated. And the inspector said, well, the bog's interesting features don't include isolation. So he gave very little weight to the argument that putting development next to the bog was going to undermine its isolation. I think the other thing that I learned from this is that they tried to protect the bog with a protection and enhancement zone, and that included a bund, and the bund was up to 3 meters high, between 2 and 6 meters wide. And that came back to haunt them because that was described as an alien feature in the landscape. So that was another nail in the coffin.
Thanks, Mary. I mean, the point about water supply, I mean, I think that's going to be an issue that we see more of, actually, as there's more and more people and more developments, but at the same time, less and less water in the right places. Those who've been involved in the Newmarket, the saga of Newmarket rated development, Hatchfield Farm, will know that's been an issue there about the impact of water abstraction. The Environment Agency's been involved in some major abstraction stuff. So I think that's going to be a theme of the future. We need to move on, and we're going to move on towards the local plan decisions. There's been a number of local plan inspectors' letters in recent days, some of which we'll be covering next week and thereafter. But today we're going to feature the latest exchange, including today, between the examining inspectors of the Chiltern and South Bucks local plan and the two local authorities promoting that plan. Chris, you're going to kick off this section.
I am, but first of all, just before I do, I just want to compliment Mary on wearing a hat in 26-degree heat. I mean, you look fabulous, but I don't want to be outdone, actually. And I've got a hat. This is from my rugby club where I coach. Yes. And I'd like you to acknowledge just how painfully hot that is.
Charlie, can we take contingency measures when we lose 2 panelists to heat exhaustion in about 20 minutes?
We don't have aircon in chambers, but I've got the fan from the Clarks from here.
Yeah, and we all thought your hair move naturally. Okay. This is yet another story in the saga of the duty to cooperate. And there was a feeling for a while that it was a duty that would never really be breached because it was just a duty chat. But in reality, what we're seeing is an increasing number of inspectors relying on the duty to cooperate say your plan is not doing the heavy lifting it needs to. This time, the Chiltern and South Bucks local plan, Matthew Birkinshaw and David Troy, the inspectors there, and they issued a letter on the 7th of May in which they considered the duty to cooperate. That really is all that is dealt with in the letter. They point out that the position for Slough, the neighbouring authority of Slough, and its inability to meet its housing needs had been, their words, a long-standing matter for discussion. So it was something that South Bucks and Chiltern were well aware of, and the strategic matter of that unmet need was known at a very early stage in the preparation of the Chiltern and South Bucks plan. Now, what they observe about the dialogue and the ongoing discussion is that there was a process whereby it was well known that this might lead to a failure to address the duty to cooperate, because Chiltern and South Bucks were making no effort to actually deal with the unmet need from Slough. There was a duty to cooperate meeting, but then nothing happened for 18 months. So as for the ongoing dialogue and the constructive dialogue, that was very noticeably absent. And they noted that lengthy period of no further discussion. Now, there was a bit of a flurry of activity just before the examination process. And what was being produced was something called the WAGS, nothing to do with football this time, the Wider Area Growth Study. And this brought together Chiltern, South Bucks, Windsor and Maidenhead, and they were looking with Slough about how to accommodate the need. But what the inspectors said is that that was only part one. You haven't done part two, and that is undoubtedly about future need. Now, I find this really interesting because what the inspectors have said and why they think the duty to cooperate has failed is that the authorities can't rely on a report and say we'll address this at some time in the future through future plan making. They've said you need to deal with it now. This is outstanding need and you need to deal with it at the moment, and don't put it off to some future plan preparation. Now, in doing that, they have relied on the PPG. This is in paragraph 19 of that decision letter. It reminds us about changes to the PPG, and footnote 9 is reference to paragraph 22 of chapter 61. I won't read out the whole number for the enthusiast, but I can see from that is the 2019 update. And that says inspectors will expect to see the strategic policy making authorities have addressed key strategic matters through effective joint working and not deferred them to subsequent plan updates. And that is such an important piece of guidance that the inspectors have relied upon it, and they've made clear putting this off to the future is not the answer. And I think that is such a positive aspect of this. As for the need for agreement, the duty to cooperate doesn't require the inspectors properly acknowledge, and we'll come on to that in a minute, that there needed to be agreement on all strategic matters. But at the same time, they'd expect to see comprehensive and robust evidence of efforts made to cooperate and any outcomes achieved, and have that thoroughly tested at the examination. And they said, based on the evidence we've seen, we don't see that comprehensive and robust evidence and efforts to cooperate. And so they also noted the lack of a statement of common ground. So it's a really detailed analysis of the issue. They've taken into account the evidence. Now, what comes back on the 12th of May is a letter from Buckinghamshire Council, which is now a combined authority, addressed to the inspectors. And this letter is from Steve Bambrick. And hello, Steve, if you're watching. I know you very well from when we did the local plan in Northwest Leicestershire. I have to say, this letter, with the greatest respect to you, Steve, is not your finest work, okay? It looks like quite a bit of petulance. There is an outright criticism of the inspector in several ways in which they've addressed it. And yet, when you read their letter carefully, they undoubtedly have looked at the wider context. And this letter is, in effect, saying, we don't agree with your conclusions and we think you've got it wrong. So where that is going to go, I don't know. But we got an update yesterday, which is on the 20th of May. We have the inspectors writing back to Steve Bambrick, and saying, we understand you'd like to have a meeting and you'd like to discuss this and have a hearing about this. And what's interesting here is that PINS have made clear that they can't do face-to-face meetings at the moment, which I have to say is something of a concern. We only need to be 2 meters apart. And if you stood in a supermarket queue recently, you'll know that's not very far at all. So it'll need to be a virtual meeting. And then they're suggesting there'll be a virtual meeting to address this issue. But this is yet another psychodrama. It's got all the makings of South Oxfordshire Part 2. And we don't know where that's going to go. Somebody's asked the question, does it mean the plan will fail? Well, I think that all depends on how the authority responds to this letter.
Well, can I just say in response, Chris, I agree with everything you said, and there's a very good book title about how to influence friends and influence people. I mean, the comment about to allege at this stage in the words, the strength of the words used against inspectors, I almost go pro bono basis to watch when they do finally meet, because it's an interesting morning, frankly, in the light of the strength of the criticism from Bucks Council towards the 2 inspectors. But it is the key point, duty to cooperate. It's not just process. It's not just process. Yeah. Charlie.
Thanks, Sasha. A few questions before we move on to our session with Steve. Somebody has asked whether in paragraph 14 of the framework, by reference to the Waverley decision, the provision that in order to benefit from the lower 3-year supply test, the neighbourhood plan must contain both policies and allocations to meet its identified housing requirements, as opposed to one or the other. What do we think about that? I think it does, because paragraph 14b of the framework says policies and allocations. In my mind, and means you have to have both. One won't be enough. Nicola has said that her toddler has just thrown a sock at the screen. I'm not sure which stage, whether that was when we referred to when Paul was talking, very evident. And it's wonderful the way that we have our viewers' ages range all the way from about 2 or so. So that's absolutely superb. Somebody else, is my window FENSA compliant? Well, I haven't got a clue what that means, so probably not. I hope that doesn't render me in breach.
You've obviously never sold double glazing, Charlie.
No, I haven't. No, all bought it, I think. So, without further ado, let's move towards. Thank you, by the way, I should add to some of those who asked questions to Steve. I've made a note of those, and Steve, you might have seen them, and I'll try and work those into some of the questions. Steve doesn't need any introduction. We all know that he was until recently the chief planning officer of the government for 12 years in total, under different administrations and a number of different secretaries of state and planning and housing ministers. Steve, thanks again and welcome again. Perhaps first up, you can tell us, I mean, we all know basically what you did, but perhaps you can, from your perspective, what did your role as chief planner actually involve?
Oh, okay. Well, I suppose there are broadly three things that a chief planner does. One is manage the casework. It's interesting to hear the debate you've been having about casework, and knowing that every one of those cases actually was on my desk when I was chief planner, and the way in which we looked at different policy. As chief planner, you're dealing with some of the most important decisions that the planning system can deliver, so it's great to be in that role. It's a privilege to be in that role. The casework unit take, 1,500 to 2,000 decisions a year, mostly under delegated powers. All the stuff that used to go to government offices is now dealt with through the casework unit. The call-in and recovery counts for about 70, 90 decisions a year. But it is, as you've been talking, really important stuff. The chief planner then gives advice across all policy areas, tries to give policy advice as a specialist planner, which I should come back to. And that has included design. I've been really pleased that we've got a design team and a head of architecture now, which I think is great. And then the chief planner is also head of profession. So there's a role both within the civil service, embedding the profession within the civil service, but also a champion and ambassador for planning externally. So that's pretty much what it does.
Cheers, thanks, Steve. And as you know, one of our running issues that we've touched upon in pretty much every one of our episodes has been the local plan system. From your perspective, having been at the heart of government for 12 years. How do you see the local plan system being able to be improved? What key improvements do you think, if any, could be made?
Well, when I was in frontline practicing, and I heard your discussion last week, the 2004 process, which of course had a structure which had regional strategies, community strategies, local plans, as a triumph of plans within the area, I think was working quite well, to be frank. And was beginning to deliver outcomes. People were beginning to get their core strategies in place. But I think the thing that I feel that the local plans would benefit from is a much more flexible attitude. I mean, if I was going to amend the way local plans were made, I'd probably look at the way in which there's quite a rigid approach to Reg 18, Reg 19, and then the process, the examination, the adoption. And then it's still a bit like the idea that a plan is in on the shelf. The local authority has a plan. And I think if I had a real ambition, I'd try and make the plan much more a people's plan, a plan that was live and that you could update on a rolling basis, and that it wasn't just the monopoly role of the local authority to do a plan. There's a plan for the community, so why doesn't the community have more say? Let's get plans onto everybody's iPhone.
Do you think that would negate or reduce the need for neighbour planning if that was built into the district-wide, borough-wide plans?
I think neighbourhood plans have got a role. I mean, it's nearly 10 years on from Neighbourhood Plans 2011 Act. Those that have done it have found them really useful. There were lots of plans before, of course. There were lots of village plans, design plans before. And so there is a hunger for a local voice to be heard. I think you could argue that could be done through local plans. The issue, as you've been talking about earlier, is that, of course, that's only the case if people have got local plans in place. And if you happen to live in York, as we mentioned earlier, and if it was 1956 that they had the last plan, and Paul, I must say, I was hoping to retire. My retirement gift was going to be that the York had an adopted local. But it wasn't to be.
I would have taken that bet, Steve. I really would have taken that bet.
It came close. But I think that if you live in York and they haven't got a plan, then it's real, neighbourhood plans will step into that vacuum and try to create a plan where there isn't one.
That's really interesting. Let's move from plans to decision making on particular projects, applications. In your view, what does or should the future hold for decision making on particular projects? I mean, there seems to be a spectrum from, on the one hand, the sort of the Jack Airy policy exchange proposal for wholesale reform and introducing a system of zoning. Perhaps in the middle, some kind of fine tuning of the existing system, such as greater uptake of permission in principle, or continuation of the status quo. Where within that spectrum do you see the appropriate calibration being?
Oh, that's a good question. If I can borrow from Simon Gallagher. You asked me about the chief planner's role earlier, and one of the great things about the chief planner's role is you get to be the steward of the system. But one of the downside is that people can regard you as being the steward of the system and therefore the defender of it. And as many people who are listening to the program will find, that they come across people all the time who think they're better planners than you are, even if they're not a planner and know nothing about planning. And one of the frustrations within central government is that still plays out, and whether it's within the department, and I've worked with some people in the department who have known nothing about planning but think that they've got a good idea about how to improve it, and also in other government departments. Now, for me, I have to say that Jack's slightly falls into that approach where he's not a planner, but he has a view about how planning should be improved. Now, that's not to say that there's not certain elements of Jack's paper that couldn't be explored further. I'm wary about just changing a system for another system, and some of what Jack proposes, I think, is that in his paper, you still need a plan, you still need members to draw lines on maps, and you still need to have areas where development can take place and where it can't. All that is, to me, just the same process, different. I think, though, that the zoning is something that can be done now. You can zone, you can have LDOs. And I think that one of the things that the government should look at further, is if you remember, they undertook to do three things with permission in principle. It was the ability to apply for small sites, the link to brownfield registers, Part 2 registers, and they were going to make a link between local plan allocations. And I still think that there's mileage in looking further at that. Because I think if you were to have permission in principle on allocated sites, it opens the door for master planning, it opens the door for zoning, and it opens the door for some of the things that the Building Better, Building Beautiful Commission have been saying about engaging people in creating great places. And if you can do that, you get fast decisions.
Yeah, well, I agree with that. Amen to that. Steve, there's been a couple of comments really endorsing what you've said in relation to involving communities more in local plans, actually, from different perspectives, actually, and one of whose names I'm familiar with, and I think that's something that the government would be well advised to look at, actually, as a way of perhaps getting more buy-in to local plans, and arguably that might lead to greater buy-in to development pursuant to those plans. I want to move on to the issue of viability and the development economy. I was involved in a rather interesting webinar discussion this week with Robert Fort of Geraldine about financial viability and planning in the post-COVID world, and there's been one or two questions to you about that, as you may have seen in the Q&A box, about what's your take on that, and from your perspective, what further steps do you think might be done to shore up the development economy so as to avoid a significant drop in the supply of new housing, new employment and other sites over the next couple of years and beyond?
Well, it's going to be tricky, isn't it? If there was a light switch answer, then people would click it straight away. I mean, I think that there's several things arising from looking ahead about post-COVID and what the world will be like in a new world, and viability is going to be key to that, because things have changed. Things have changed from 6 months ago. And I think that there's going to be a discussion to be had about how things like high streets operate. Certainly, I'm using my local high street much more than I ever used to. Will I ever go back to driving around to Tesco's and the supermarket? I'm not sure I will. And so there's opportunities for things to become more viable than they were previously. And also that will include lots of, well, I would argue, small office space accommodation, because when people are working from home, why wouldn't they work in sort of work hubs and the like? So the viability generally about some of the things like high streets and retailing will change. But in terms of site by site, the assessment of whether something is viable, I think the government can do more in terms of extending permissions, the lifetime permissions. It can do more in terms of, still, I know they said they're going to, they've issued the stuff we talked about it last week, about looking at how they're going to change the regulations there. But I'm picking up, I think, something, Charlie, you said last week about viability in local plans. I'm probably more on this side of that being a good thing than a bad thing. I know it can be difficult and things change, and I do know that your comment last week about stifling ambition, and we need I think there's a different solution to that. But I think if you get a site in a plan which you can say is viable and deliverable, then the circumstances going forward should still mean that it is. And I think the local authorities have got a role to play in actually engaging with implementation. That's my final point on this. Someone said to me last week that a local authority had a local plan in place, recently adopted. They still had 6 people in their local plan team. They had no idea what they were doing. Now, to be honest, that for me, that's so naive, because what they should be doing is implementing a plan. And actually, it's not a plan that they don't own. It's a plan that then needs to be seen as a blueprint for development. And as a pro-development planner myself, I would never stop when I finished the plan. You need to step forward and make it happen.
Thanks, Steve. On that subject of ambition, I know, Chris, you've got a question, an associated question relating to the issue of garden communities.
Yeah, so Steve, obviously the government supports new settlements. That's writ large across the MPPF. We also see many of them failing in the present local plan system or having real difficulties, and we'll probably get on to next week about North Essex and the failure of 2 new settlements there. And the question I have really is, should large-scale residential development be permitted by central government rather than local government in order to secure delivery? And that raises possibilities of DCOs or a national plan, having a national strategy, or a different test of soundness? And also in that, how quickly could that be done? Or are we years away from achieving something that might be more positive towards these settlements that everybody wants?
Yeah. Well, I mean, I suppose a couple of things. There is an issue about, again, coming back to viability and deliverability. And I'm not talking about any specific proposal here, but there was always a worry that the local authorities would try and dump their housing into so-called settlements, which actually were never really going to take place, but they could argue that they would as a way of avoiding releasing other land. But for those that are genuinely sort of goers, or that they can fly, I think there's the DCO is one option, and the 2008 Act, as you know, doesn't allow for it now. It allows for some, but not for new settlements. And there is an argument, which I do recognise, that you could deal with new settlements through a DCO, which would comprehensively deal with infrastructure, CPO, and delivery of housing. The thing you've got to try and before you do your fingers, the thing you've got to resolve is how you resolve that through a plan making process and a community engagement. Because the last thing you want to see is this sort of development imposed on people from on high, where people feel they're completely disconnected with it, and we're back to planning being done to people rather than for people. So there is an issue there to be resolved. I'm not saying it can't be resolved, but it would need to be resolved. The simpler solution would be, and I think the government has indicated that it's up for looking at this, would be to look at the test of soundness in local plans. And it comes back to my point I made earlier about trying to keep local plans live as opposed to a closed book at the end of the adoption. I think there is a case for arguing that large-scale ambition should be dealt with differently through the examination process. And whether you keep the examination rolling for those things that you can't resolve, or whether there's a two-stage soundness test to actually address these things. We did try and do something in the MPPF in the last revision, which tried to reflect the fact that we acknowledge that some things go beyond the plan period. But I think the government will need to do more thinking in this space, because you're right. We want ambition. We want some of these developments to take place. And if they're falling at the local plan process, you've got to ask yourself, is the local plan the right vehicle for delivery?
Yeah, amen to that. Sasha, you on the issue of
I think
planning with 4 people, you had a question about neighbour plans, didn't you?
Well, I did, but I think, frankly, in view of the time, and we're banging up towards 6, I prefer, frankly, can I extend invite Steve to come back, because I've got a question, I know Paul does, and I think we've got some really good questions on the Q&A as well. So Steve, you're popular, understandably everyone wants a chunk of you, so I hope you'd consider coming back at some future stage in the near future and talking to us more.
There was certainly a huge amount of questions, so yeah, amen to that.
I'll be delighted. I need to think deeply about the goal box issue.
You need a friend, Steve.
Or else that address that issue. I really need to find my England shirt, which I wore at the game that your grandfather kicked off at, to be honest.
1910. You don't surprise me at all.
Mary, did you want to ask a question?
Yeah, my question, which is related to what we've been talking about, is whether really there is a case for more support and joined up thinking between the other arms of government and infrastructure providers to help provide support to local plans, because absent regional spatial strategies, it seems to me that there is a very big hole in the planning and the deliverability of the infrastructure side of things. And local authorities just do not have the tools or the know-how to deliver and to justify these new garden communities and large urban extensions. So, I mean, you know, whether you go for a DCO or whether you go for a decision made nationally, you need surely more joined up thinking about infrastructure.
Yeah, I mean, I have to confess, in lockdown, I've been watching reruns of W1A. And one of the things that most often is said on W1A is the word brilliant. And that would be my response. It's a brilliant idea. And I think that you're right. The government needs to get better at joining up some of these things. It's not just things like HIF and HIF funding, but as if you're relying on DFT to take a decision on their funding stream, and their timescale for making that delivery is having no regard whatsoever to a local plan process, or indeed a planning application process, or indeed a DCO process. It's not good enough. And I think that we don't want things to fall because the government is not getting its act together in agreeing, or not, how to fund it and how to do it, which comes back to the point that I think Paul was making earlier about you do need some sort of strategic overview.
And finally, Paul, quick question from you on appeal success rates.
Yeah, just a quick one, really, Steve, and it's who's in charge from the knowledge that you have from the inside. It's been well publicised that 2014, 2/3 of public inquiries resulted in appeals allowed. 2019, 1/3 of public inquiries resulting in appeals allowed, of which 28% of housing appeals results in appeals allowed from those public inquiries. So from the view from the inside, who's the one that's calibrating the judgments? Who's the one that's making sure that the decisions that are being taken are actually the decisions which reflect the Secretary of State's policies? Brackets, help, close brackets.
I mean, because your stats you show there, I mean, could just indicate that over the years, more and more people have got local plans in place, and Section 38(6) is biting, and that you know, that's why you're not winning so many appeals. Having said that, the Secretary of State would not intervene with the planning inspector's decisions. They're impartial, independent. There are some things that the Secretary of State can do, and one of the things it can do is ensure that you know, it's the same system for everybody, and that applies to PINs as well. So we've made it clear that the PINs have it's the government's planning guidance, it's the NPPF that we all use the same thing. The Secretary of State can recover appeals, and if he feels that there's an area where he needs to examine whether or not PINs are interpreting policy appropriately, then in the way that it was envisaged, then he can recover appeals and make decisions accordingly. And that's really quite a powerful signal to the industry about how policy is meant to be interpreted. But in terms of who's in charge, well, you know full well that the decision is in the hands of the decision maker.
Beautifully done. Thank you, Steve.
And in one sentence, if you could make one reform to the planning system or planning policy, what would that be?
I'll bring back strategic planning.
Hey.
Okay. Right. Thank you very much, Steve, for that really interesting insight. We're now going to move to praise of the week. Paul, over to you.
Yeah, and it's going to be a disappointment to Steve, I'm afraid, because Steve was in the running on this one, as was Chris. But in terms of the best hair in planning, it would have to go to Roger Clues, who is also, by happenstance, the inspector in Braintree and Colchester and Tandridge, who's issued a decision today with suitable robustness. So I'm not going to talk about the decision because that'll take too long. It's all hair, and I'm sorry, Steve, you came second.
I better not ask who's got the worst hair in planning in case I get the wrong answer. Nudge of the week, Mary.
So nudge, I think nudge is me actually. But
he's nudged me out. He's nudged me out.
I've nudged you out. Yeah.
Yeah, I did there.
The government has still not sought to issue the legislation that it knows it needs to do to extend the life of planning permissions, and it just needs to get on with it. The other parts of the union have done it. I don't know why it hasn't been done. Killian Garvey has a petition for Parliament. If you look him up on LinkedIn, Killian Garvey is a very reserved young man from Liverpool, and you probably never heard of him, although he does tend to be on LinkedIn about every 4 minutes. But look him up, look his petition up, get it signed, and let's get them dealing with this in Parliament.
And given how often Paul keeps referring to that, I kind of think we ought to refer to that as Tucker's Law. I was thinking, 1,000 years' time, Paul, look at your graveside. Paul Tucker QC persuaded people to reform Section 73, subsection 5 of the Act.
I think that's the name of his retirement sweet shop, Tucker's Law.
Absolutely. Tucker's Law. Sasha, what's coming up next week?
Well, I can't contain myself, frankly. We have got an inspector to come and tell us about the inside workings which is absolutely brilliant. We've got a senior inspector coming on board. We're going to talk about the two most famous urns in the British Isles in the Supreme Court judgment in the Dill case. And we're also going to talk about a Secretary of State concession in the High Court, which is really, really consequential. So
and also, David Smith, I gather, is a Tottenham Hotspur fan, so perhaps the show will finally feature that which is now very overdue, thanks to you, Sasha, which is a Spurs shirt. So, David, if you're listening,
quid pro quo, happy for that, as long as I can bring all the Arsenal League titles in the background.
Ooh, cliche. Well, everybody, thank you so much for joining us again. In particular, once again, Steve, thank you for coming on and facing our questions and giving that really interesting insight. Please join us again next week, same time. Can
I just make one point for our viewers to say, and this is Paul's point and mine and yours, that we're going to a world of Zoom 5, so people need to update in order to correctly see us. So if they can, it only takes literally a minute, but update to 5, otherwise you will find it difficult to join. And we'll get 7,000 emails saying we can't get in.
The best thing about next week is that it gives Sasha and me a complete alibi for not attending our annual Chambers meeting, which feels full details, as always, of our episode next week will be on the LinkedIn page. As I said, same password, same ID. Please don't forget the donations to the NHS if you're so inclined, or to charity of your choice. Sasha has not been able, I'm so sorry to say, to authorise me to share my screen. I was going to leave you with the image of a particular brand of confectionery called Fun Nuts. We will explain what that's about next week. Goodbye, everybody. Have a lovely weekend. Enjoy the sunshine. Stay well, stay safe, and see you next week. Cheers.
Cheers.